now on to dual agency. And again, Iowa law requires that you must disclose dual agency. Not do it undisclosed and not have both parties know that you represent the buyer and the seller in the same transaction. Career, what I would recommend doing is number one, when you meet with your seller and you're going to be listing the property, I would talk about the potential for dual agency then and get their feel for whether they're going to allow you to do that in the process or not. It's really your client's decision. Yes, your broker might have a policy on it, but really, if they do have a policy that allows dual agency, and I know a lot of agencies do allow it because Iowa allows it, ultimately your clients get to make the decision. So what I would recommend you do is when you're listing that property and you're talking about agency, just discuss the potential for dual agency and decide whether it's going to work for them or not. Most clients allow dual agency. They think, yes, go get me a buyer. And I know in a lot of smaller communities around the state, your opportunity to do dual agency, tongue twister, to do dual agency actually is pretty high, is the feedback that I get versus bigger cities where we maybe have more agents and we don't do dual agency as regularly. But it's got to be their decision. And I know a lot of folks that are maybe attorneys, for example. Most of the attorneys I've worked with in my career do not dual agency. And the analogy that they give is, if you and I were getting divorced, would we use the same attorney to represent us? Probably not. And that's how they feel about real estate as well. But I would have that conversation when you list it. Then if they're open to the idea of dual agency, again, as you're meeting buyers, make sure that you're disclosing what that relationship looks like. If they don't want to do dual agency, then ask, maybe if they're not working with another agent, if you're able to refer them on to another agent in your office or something like that that could represent them. If they're okay with dual agency, what I would have them do is sign the agency and dual agency forms, then write the offer. Don't write an offer up and then drop this on them. Talk about that on the front side, obviously, before we learn anything confidential. We need to be doing that anyway. Get dual agency signed, then I usually do seller disclosure, then the offer. Then when you turn around and present it to your seller, I would send over the dual agency, have them sign off on it, and then present the offer. The reason I do that, and this might be splitting hairs a little bit, but the reason I do that is I don't want a seller to decide whether they're okay with dual agency or not based on what my offer looks like. They either need to be confident in me representing both parties, honestly and fairly, or not. Then we'll work through the components of the offer, okay? So I think this gave you a good description again about what you must keep confidential. But then here, this last part talks about what a dual agency agreement shall contain. And I thought this might be a really good quick review for you because it's still going to talk about representation, the licensee's duties of cold AC. Remember that from agency before: care, obedience, loyalty, disclosure, accounting, confidentiality. It's going to address that those material adverse facts must get disclosed no matter what. And then there's going to be a statement that says representing more than one client in a transaction could present a conflict of interest. And that they, because they might rely upon the broker's advice and client's interests may be adverse to each other. So that means as agents and brokers, we've got to be impartial between the buyer and seller and represent neither the buyer or seller to the exclusion or detriment of the other. So that's just a little bit of language that should be pre-typed in your dual agency agreements provided by your broker.